If a medical provider obtains a patient's consent to perform one procedure but ultimately performs another, has the medical provider committed battery? We explore that question in Christman versus Davis. Paul Christman sought treatment for gum recession and root exposure from periodontist Gordon Davis. Davis recommended treating Christman's condition with a tissue graft. A tissue graft is performed by making incisions around the exposed root and then grafting donor tissue onto the root. Christman consented to a tissue graft. After starting the procedure, however, Davis decided to perform a flap procedure instead of a tissue graft. Like a tissue graft, a flap procedure is performed by first making incisions around the exposed root. However, no tissue graft is performed. Rather, the periodontist applies a protein to the patient's gums to help adhere them to the tooth. Christman's flap procedure wasn't successful. Christman sued Davis in Vermont State Court. Initially, Christman asserted claims for malpractice, lack of informed consent, and battery. He later dismissed his malpractice and lack of informed consent claims and proceeded solely on his battery claim. The parties disagreed as to whether Davis had discussed the flap procedure with Christman and whether Christman had consented to that procedure. The parties agreed, however, that a flap procedure is less invasive than a tissue graft. Davis would have had to perform the steps of a flap procedure to determine whether he could perform a tissue graft. The trial court granted Davis's motion for summary judgment. Christman appealed to the Vermont Supreme Court.